When you're hurt in a car accident or suffer an injury, you can bet the other person's insurance will be calling you right away, trying to get you to make a statement. What's legal when it comes to these recorded statements, and could it ever be used against you? Here with the answers is Colorado's best legal expert, Phil Harding from Harding & Associates. Welcome to the show today. I just saw you yesterday.
I know, weird.
On a bike.
2 days.
2 days in a row with Phil. But I love this, what we're talking about today, because you get this question a lot, and I told you I had this question like 5 years ago.
Yeah. It is a big question, and our viewers, I get a lot of these questions coming in, and one of the main questions that comes across is, if I give a statement, first of all, do I have to give a statement?
That was my question.
If the insurance company calls you. And there's a statute out there. Generally, these statements can be used against you. So any statement that an insurance adjuster wants you to make that's on the other side, don't do it. The exception is that if it's your own insurance adjuster, you do need to cooperate with them, but there is a law out there that most people don't know about. And I want to go into this because even a lot of attorneys don't know about this. And we have a graphic for it. It's CRS 1321-201. And essentially what it says, and the heading of this even says settlements, releases, and statements of injured parties. And subparagraph 1 essentially says, if a person is injured and that person is treated for any injuries, no person or agent of any person whose interest is adverse to the injured party shall, then you drop to subparagraph C, within 15 days after the occurrence, obtain or attempt. Thank you.
Any statement.
My teeth are falling out. A statement here.
Right.
And so I hear it all the time from people that have the insurance adjuster call them up in 2 or 3 days afterwards.
Oh, mine called the day of the accident.
Isn't that weird? But there's a famous case. Now, this case was back in 1978, and this gentleman was injured in a grocery store. The store's agent took a statement from this person 3 days after the injury. Now, this case went all the way to the Colorado Supreme Court, and it was ruled that this evidence of making a statement within, here it was 3 days, but within 15 days of the injury, cannot be heard as evidence either in front of a judge or a jury.
Really? But most people don't know this. And
most attorneys don't know that.
Most attorneys, I mean, that's surprising because when I got the phone call, I just felt that I had to divulge everything because, it was an insurance agent. I didn't know that I had rights.
Right.
So if an attorney doesn't even know it, how do we know it?
Well, by watching the show, right?
That's why we watch you.
And, here's a really important thing that I want to talk about. Not only can this be voided out if you made a statement. It's inadmissible. I don't know why insurance companies are doing this, but there's another thing. The Colorado legislature, and the reason why we went into this, understands that right after you are injured, you may not know the extent of your injuries. And because of that, they want to give you a couple weeks before someone makes a statement on that. Now, I want to go into something else. A lot of times insurance companies come in and say, hey, I want you to sign a release for medical records. We want to get your medical records. And everyone feels like, I got to sign that, right?
Right, you just feel like you have to do it.
And let me just tell you, when you sign one of those things, this is what's going to happen. It's generic enough that they can go out and find, when you were 8 and you sprained your ankle playing soccer, they'll get those records. But more importantly, they are going to go back and get not only your medical records, but your medical billings. And we've talked about this before. And this is called the collateral source doctrine. I don't want you to sign those things. I don't want the insurance company to know about these medical billings. And we've talked about it before. It's called the collateral source doctrine.
Okay.
Remember throwing that word around?
Oh, you always throw those words around.
I know. And what that means is, let's say you have health insurance or Medicaid or Medicare. Now, when you see those medical bills, those will be reduced by your health insurance. They'll say, the hospital billed us for this ER visit $5,000, but we're reduced it because we have this contracted rate, and so we're only paying $2,000 of it.
Then who has to pay the rest?
Well, that's how it gets knocked down. Remember, the health insurance says we have this contracted rate.
Yeah.
Now, the other side's insurance company wants to see that $2,000. Because they're going to come back and they're going to say, we know about that billing, and yeah, it said it was $5,000, but only $2,000 was paid. They don't get to see that. The other side's insurance company does not get to see that, and that's the collateral source doctrine. So you can make more money from this when you don't sign that release. Now, a lot of people come back to me next, and then they say, Do I let my clients give statements? And I got to tell you, sometimes I do. And when I do, it's solely for the purpose to determine if it will either help my client or help resolve the issues of this case. And if I have a client give a statement, because a lot of people want to know if they're going to give a statement to an insurance company, what should they do? You remember playing hot potato when you were little?
Yes.
And what do? When someone throws the hot potato to you,
Throw it right back.
you throw it back as quickly as possible. You don't
Yeah.
freak out.
Right.
But so you treat the question like a hot potato. Get rid of it as quickly and accurate as possible. Be truthful and don't try to win the case.
Don't try to win the case. And I think the take-home message here is call an attorney. Don't do it on your own. Don't give those statements. Don't sign anything. Call an attorney.
Right.
Right? All right. We want to remind our viewers quickly that they can go to our website, coloradosbest.tv, and see past segments so you can learn all of this stuff and become more educated.
Please look at it.
If you have any legal questions for Phil, he wants to hear from you. Just log on to coloradosbest.tv, look for his photo, and click right there. You can submit your legal questions, and he takes the time to answer them personally, and he might even address your question right here on Colorado's Best. If you would like to contact Phil at his office, Harding & Associates, the number's 303-762-9500, or online at hlaw.org. Coming up.